Good day, my name is Gina Arobo, and in this video, we will discuss Section 5 Compensation, Article 1279 and 1284. First, compensation is defined as a mode of extinguishing obligations whereby two persons in their capacity as principals are mutual debtors and creditors of each other, with respect to the equally liquidated and demandable obligation to which no retention or controversy has been timely commenced and communicated by third parties. The requisites, therefore, are provided under the Article 1279 of the Civil Code, which reads as follows. In Article 1279, in order that compensation may be proper, it is necessary to be 1. That each one of the obligors be bound principally, and that he be at the same time a principal creditor of the other. For example, Calista owes 5,000 to Marina and Marina owes 5,000 to Calista. In this case, they are principal debtor and creditor of each other. 2. That both debts consist in a sum of money, or if the things due are consumable, they be at the same kind and also of the same quality if the latter has been started. For example, number 1, Ramoncito owes 100 sacks of rice to Salem, and Salem owes 50 sacks of rice to Ramoncito. In this problem, there can be compensation because both the thing due is generic and are susceptible of substitution. In the second example, Ramoncito owes 100 sacks of Milagrosa rice to Salem, and Salem owes 100 sacks of brown rice to Ramoncito. Though they have the same quantity, they differ on the quality. That's why there will be no compensation in this example. 3. That the two debts be due. For example, Calista owes 5,000 to Marina payable on June 6, 2022, and Marina owes Calista 5,000 payable on June 7, 2022. Now, the question, can there be legal compensation on June 6, 2022? No, because one of the debt is not yet due. There will be no legal compensation until the due date June 7, 2022 because it's needed that the two debts are in due to have legal compensation. Number 4, that they be liquidated and demandable. A debt is considered liquidated when its amount is clearly fixed. It is unliquidated when the amount is not fixed because it's still subject to dispute or to a certain condition. When is an obligation not demandable? One is that when there is one period and it has not yet arrived, including in the case when one party is in a state of suspension of payments. Number 2 is that when there is a suspensive condition and it has not yet happened. Third is when the obligation cannot be sued upon. Last, in Article 1279, number 5, that over neither of them there be any retention or controversy commenced by third person and communicated in due time to the debtor. For a situational example, Tyrone owes Euhens 1,500,000 and Euhens owes Tyrone 1,500,000 plus another 1,500,000 to Train. Train, who claims to be an unpaid creditor, has garnished the credit. Train files garnish proceedings against Euhens to Tyrone's credit. So, a garnishment or wage garnishment is a money is legally withheld from your paycheck and sent to another party. It refers to a legal process that instructs a third party to deduct payments directly from a debtor wage or bank account. Typically, the third party is the debtor's employer and is known as the garnishee. So back in the problem, there will be suspended compensation or no compensation will take place between Tyrone and Euhens because there is a controversy commenced by Train. If Train will win the case he filed, there will be no compensation between Euhens and Tyrone. But if he loses the case he filed, there will be a compensation between Euhens and Tyron. And that ends the Article 1279. Now let us proceed to another article still under Section 5 Compensation, the Article 1284, where stated that when one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. Compensation of rescissible or voidable debts. Rescissible, Article 1381, and voidable obligations in Article 1390 are valid until they are judicially rescinded or avoided. Prior to the rescission or annulment, the debts may be compensated against each other. For example, Draco owes Crema 1,000 pesos. Subsequently, Draco, through fraud, was able to make Crema sign a promissory note that Crema is in debt to Draco for the same amount. The debt of Draco is valid, but that of Crema is voidable. Before the debt of Crema is nullified, both debts may be compensated against each other if all the requisites of legal compensation are present. So back to the Article 1284, prior to being judicially rescinded or annulled, recessible or voidable debts are valid debts. The parties have the option of not rescinding or annulling them. As a result, they can be compensated against each other until they are declared void by a court of law. If the prospective period of the rescission or annulment of the debts have already lapsed, there is automatic compensation and the same will not disturb anymore. In another case, if the debt is rescinded or annulled, the compensation is also automatically cancelled and there shall be restitution of what each party had received before the rescission or annulment. And that ends my discussion in Article 1284. And this ends the content of my video, Article 1279 and 1284 under the Section 5 Compensation. Thank you.